Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. In this video today I have come up with another landmark judgments from the 1st of May to 15th of May 2023. ये सीरीज हमने एक्सक्लूसिवली लीगल बी पे स्टार्ट की है एंड अगर आपने बाकी के वीडियोस मिस किए हैं then you can go and visit the playlist and check out all the videos. Every 15 days I come up with the judgments that are landmark which have certain law points discussed in them of the Honorable Supreme Court of India and कुछ High Court के भी judgments मैं try करती हूँ कि मैं इस वीडियो में cover कर सकूँ. And you can also download the PDFs every month that are available for all the judgments compiled for the entire month. बट ये सब आप मिस मत कीजिएगा, इसलिए डोंट फॉरगेट टू सब्सक्राइब टू अ यूट्यूब चैनल. यू कैन प्रेस द बेल आइकन. Along with this, also there are various courses available at iExamBee. So check out the website www.iexambee.com. And also if you have any queries, you can write to us on hello@iexambee.com. I have some more updates for you. There is a new batch for SEBI Grade A Legal Exam that is starting on 29th of May. So आप उसकी डिटेल्स भी चेक कर सकते हैं. इसके साथ ही UGC नेट एग्जामिनेशन जो कि जून में कंडक्ट होने वाला है, उसके लॉ के फ्री मॉक टेस्ट अवेलेबल है. फॉर दैट यू कैन चेक द वेबसाइट इमीडिएटली एंड स्टे ट्यून्ड फॉर मोर सच काइंड ऑफ कोर्सेज कंटेंट ओनली एट iExamBee's LegalBee. The landmark judgments from the 1st of May to 15th of May I'm going to discuss in this video today. And yes, जितने भी judgments मैं इस वीडियो में कवर करने वाली हूँ उसकी समरीज मैं आपको बताऊंगी. बट आई वुड रिकमेंड ईच एंड एवरी पर्सन जो कि लॉ फील्ड से जुड़ा हुआ है, try to go through the judgments. If you are a law student especially, you should have the habit of reading judgments as it will help you a lot in building your legal vocabulary and will brush up many of your concepts if you have already studied those in your law school also. अगर आप lawyer है तो obviously आपको judgments की ज़रूरत होती है, citations की ज़रूरत होती है, you have to keep yourself updated. And if you are preparing for judiciary exams as well, there is no doubt that you need to read judgments regularly. Starting with the first case, which is of the Honorable Supreme Court of India that was passed on 1st of May 2023. इस केस में शिल्पा शैलेश वर्सेस वरुण श्रीनिवासन. इस केस में क्या हुआ था? The apex court has held that it can dissolve a marriage on the ground of irretrievable breakdown. Irretrievable breakdown theory काफी famous है family law में, we all know about it. So Article 142 of the Constitution क्या है? This is when the Supreme Court of India can exercise its extraordinary powers to do complete justice in a case. Even if the petition is not seeking that, but the court can, invoking this article, do complete justice to the parties. This is the discretion which rests with the Supreme Court of India. And इस केस में irretrievable breakdown के कारण parties को divorce दिया गया है by the Honorable Supreme Court. They had actually filed divorce by mutual consent in the lower court and उसका transfer petition लेकर वो Supreme Court में आए थे. So this was the original thing that they had come up by a transfer petition, but on the grounds the court has granted them divorce on the grounds of this theory, which is irretrievable breakdown. Kailash Vijay Varghia versus Raj Lakshmi Chaudhary and others. This judgment was passed on 4th of May 2023 by the Honorable Supreme Court of India. इस केस में क्या हुआ है? इस केस में बेसिकली जो कंप्लेनेंट है उसने फाइल किया है रेप केस अगेंस्ट बीजेपी लीडर्स कैलाश विजय वर्गीय, प्रदीप जोशी एंड जिष्णु बासु. In West Bengal in November 2018, she alleged that rape incident has taken place. But finally, this case has come up to the Honorable Supreme Court by way of a petition that was filed for 156 clause 3 directions to be given to the magistrate. And then it came up to High Court has actually remitted the matter back to the learned magistrate that he should examine and apply his judicial mind and then exercise his discretion whether he should issue directions or not. फिर ये मैटर वापस सुप्रीम कोर्ट के पास आया बिकॉज जो कैलकाटा हाई कोर्ट ने मैटर रेमिट बैक किया था, रिमांड किया था बेसिकली नवंबर 2020 में, उसको सुप्रीम कोर्ट ने अफर्म किया है. उस ऑर्डर को सुप्रीम कोर्ट ने अफर्म किया है एंड वापस से लर्नड CJM को डायरेक्शंस दिए गए हैं that the CJM should apply his judicial mind and then decide whether 156 clause 3 directions should be given to the police officers or he should take a recourse under section 202 of CRPC. And कोर्ट ने इस पॉइंट पर ये भी डिस्कस किया है दैट जब मैजिस्ट्रेट के पास ऐसा केस आता है तो उसके पास 2 से 3 रास्ते होते हैं. फर्स्ट इज 156 clause 3 of CRPC can be availed, directions can be given for cognizance, or else another thing that can be done is section 202 के हिसाब से इंक्वायरी होल्ड की जा सकती है जो मैजिस्ट्रेट खुद कंडक्ट कर सकता है. सो दिस इज समथिंग विच सुप्रीम कोर्ट हैज गिवन डायरेक्शंस टू द मैजिस्ट्रेट इन दिस पर्टिकुलर केस. The next case is Calcutta State Transport Corporation and others versus Ashit Chakrabarti and others. This judgment was passed on 8th of May 2023. In this case, the Supreme Court has upheld the decision of Calcutta High Court and has, which actually has been challenged by the appellants. What the appellants have claimed, they have claimed waiver. Waiver means what? Everybody knows, I think so. Waiver means when you are waiving off some of your rights and benefits, and here retirement benefits of an employee of the Calcutta Road Transport Corporation. He was working there and he is going to get certain retirement benefits after claiming VRS, जिसे हम कहते हैं कॉमन टर्म्स में. तो ये एक सर्विस लॉ का केस है एक्चुअली. तो उसमें सुप्रीम कोर्ट ने ये रिजेक्ट किया है दैट इसको waiver नहीं माना जा सकता. Reason being that just the grounds that were being the arguments that were being put forward by the court, by the petitioner, were that there were some wrong deductions from the salary of the employer and he was treated as a member of the CPF scheme. So अगर वो CPF scheme में continue करता है, so he cannot be raised, this cannot be raised as a ground to defeat his rightful claim for pension. So उसे pension के benefits नहीं मिलेंगे, retirement के benefits नहीं मिलेंगे because he has, by continuing as a CPF scheme member, he has waived them all. So ऐसा जो argument petitioners ने दिया है इसको completely Supreme Court ने reject किया है and Supreme Court ने कहा है that it is not in dispute that respondent has exercised his right to receive pension from 1990 regulations in 1991, and after taking VRS, that is voluntary retirement from the services, he has a right to get the pension as well. It is not his fault, so the corporation is going to give him the entire retirement benefits and the pension should be released immediately. ऐसी direction Supreme Court ने दिए है इस particular case में. Sri Vishnu Construction versus Engineer in Chief Military Engineering Services and others. This is another landmark judgment in which arbitration dispute discuss किया गया है. Basically arbitration के बारे में retrospective and prospective effect का लॉ पॉइंट यहाँ पे डिस्कस किया गया है. एवरीबडी नोज आर्बिट्रेशन एक्ट को अमेंडमेंट आया 2015 में. सो दिस वाज अ केस दैट वाज एक्चुअली टेकिंग प्लेस बिफोर द 2015 अमेंडमेंट, बट देन एन एप्लीकेशन वाज मूव्ड आफ्टर द अमेंडमेंट टुक प्लेस एंड दैट एप्लीकेशन वाज अंडर सेक्शन 11 clause 6 of the act, that is Arbitration and Conciliation Act. So that was for appointments should be made. But then the question that arose in this particular case, the question in dispute was that shall this application be entertained as per the amendment or it should be treated as per the provisions existing earlier. So the Supreme Court has come to this conclusion that Amendment Act is having prospective effect and this application has to be entertained as per the situations that were prevailing or the provisions of the act before 2015 amendment. Sachin Arora versus Manju Arora. This is another landmark judgment of Supreme Court. This has been quite in news as well, that the couple, basically they were having certain disputes and they went to family court. The wife has alleged his husband for adultery, and for securing proofs she has made application before the family court that the hotel where she alleges his husband to go, and she wants certain kind of proofs for proving that adultery has been committed by her husband. So she has sought help from the family court, and family court also has given directions to the hotel for giving certain records. But then the question has arose about the right to privacy. So the Honorable Supreme Court has held that right to privacy is not an absolute right, and in such kind of cases, especially where question of divorce is being discussed, adultery has to be proved, then right to privacy is of course subjected to reasonable restrictions. We cannot say that it is in the public interest that we are protecting the right of the husband over here. So the wife can procure production of evidence on these grounds, and family court has those powers to issue directions as well. So this was held as valid, and right to privacy violation is not being has not taken place in this particular case, was held by the Honorable Supreme Court. Another landmark case, VR Sunil Kumar versus Union of India and others, passed on 12th of May 2023. In this case, basically, the Apex Court is hearing what has heard, basically, special leave petition filed by VR Sunil Kumar, who is a former scientist at ISRO. So he was a very famous scientist, he was former scientist. Again, his dignity was questioned. Basically, it was found that he was having some kind of collaboration, or he was found that he was having some kind of relations with an organization which is suspected and which is a foreign organization. So on that grounds, basically his job was taken from him and he was dismissed from his services. So that is something which he challenged before the Kerala High Court, before the administrative tribunal, that is Central Administrative Tribunal, and then finally he came to the Supreme Court under writ petition. So the Supreme Court has also rejected his petition and has actually held that when the question is relating to someone, the national security, then of course if he is indulging in unauthorized association with any foreign institution, and if especially it is taking place in certain areas which are already in doubt, which are already promoting certain illegal activities which are a threat to the nation's security, even if it is relating to research, then also his dismissal from services is something which is rightly done by the organization, and that was actually held as valid by the Honorable Supreme Court. Next judgment I will be taking up from High Courts now. Allahabad High Court has discussed another important concept rather relating to bails. Very important. Proclaimed offender. Can he be granted bail? That is anticipatory bail, which is the legal dispute which is in question in this particular case. And the High Court of Allahabad has granted anticipatory bail to proclaimed offender and has held that section 82 of CRPC and section 438 of CRPC, if we read both of these provisions, it is nowhere mentioned that you cannot grant anticipatory bail to a proclaimed offender. Bail is actually a discretionary power of the court, and if certain criteria are met, that there is security and the presence of the person can be secured, then definitely he can be granted bail and anticipatory bail as well. The only thing is that in anticipatory bail, the court has to be more cautious. That is the only thing that has to be seen. But if he is a proclaimed offender, then there is no set law that he cannot be granted anticipatory bail. So this was another very, very important point that was discussed in, by Allahabad High Court recently on 3rd of May in Udit Arya versus State of UP case. Meherban Hassan Babu Khan versus State of Maharashtra, another judgment passed on 3rd May again by the Bombay High Court. In this case, the accused was charged for rape and also under POCSO Act. So basically what was alleged in this particular case, that there was a consensual sexual relationship between the victim and the accused. So the question that came into existence in this particular case was that whether the victim was actually under 18 years of age and whether provisions of POCSO Act are attracted or not. So that was the question. But then when the medical tests were conducted, it was found out that her age was not exactly found out, but her age was found between 15 to 70 years. So the argument that was raised that just an estimate of her age cannot be the basis for conviction for that accused. Definitely he will be getting the benefit of doubt in this particular case, because if suppose, and one more argument that was raised by the prosecution, that the wisdom tooth has not come up yet, so therefore she is below 18 years of age, is completely baseless. You cannot say that this is conclusive proof that the person is below 18 years of age. And if the victim is not below 18 years of age, it is not proved that she is below 18 years of age, then POCSO Act cannot be applied on this particular case. And remaining part, that is rape section, also consensual sexual relationship, also brings the accused out of the clutches of that particular case, and therefore the Bombay High Court has actually released him. He has acquitted him in this particular case. So this is also a very important judgment passed by the Bombay High Court. The last discussion judgment that I have taken for discussion in this video is Gamescraft Technologies Private Limited versus Directorate General of Goods. So in this case, the Karnataka High Court has actually discussed another very important point, that is relating to playing of games like Rummy online. Okay, Rummy is a game of cards basically, and that is being played online. So there is a Gamescraft Technologies Private Limited company that has come up with a writ petition before the Karnataka High Court in this particular case, and has held that gambling and betting, ये कैटेगरी में रमी, वो भी ऑनलाइन प्लेइंग ऑफ रमी को नहीं रखा जा सकता है. गैम्बलिंग एंड बेटिंग की कैटेगरी में ये गेम नहीं आता है. दिस वाज द प्रेयर दैट वाज मेड बाय दिस पर्टिकुलर टेक्नोलॉजीज, बिकॉज it was said, it was claimed that this particular game should be brought under the slab entry 6 of schedule 3 of goods and services act, that is GST act 2017. so उस हिसाब से उस पर GST लगना चाहिए. But what they prayed, that this game is of skill and not of chance. So the court has actually held that this is a game of skill and not of chance, and all the show cause notices also that were issued against the against the petitioner, that is this company, by the respondents, were actually caused by the Karnataka High Court in this case, and it was held that it is illegal and arbitrary. We cannot say that this game is actually a game of chance, and we cannot tax them under this slab of GST entry 6 of schedule 3. This was held by the Karnataka High Court in this particular case. So this was all that I had to discuss with you all from 1st to 15th May. There are numerous judgments, let me tell you. स्कोप बहुत है पढ़ने के लिए. मैं चाहती हूँ कि आपको मैं क्रिस्प कंटेंट दे पाऊँ कम टाइम में. फिर भी अगर आपके कोई भी क्वेरीज हैं, आपको कोई केस नहीं समझ में आया है, या आपको किसी केस के साइटेशंस चाहिए, आप हमें ज़रूर रीच आउट कीजिए. वी विल ट्राई टू ब्रिंग आउट whatever we can to you at the most in the comment section, or else if you can write to us on hello@exambee.com also, we will surely try to come up with a resolution for your queries. So don't forget to subscribe to LegalBee and stay tuned with us. Prepare 50% faster for all the exams that you are preparing for with iExambee. Thank you everybody.